Hey, Richard. How you doing? There you go. Good. Yeah, good. Jump right back in. Okay, we're going to get started here. Right, so welcome to the February 26th Caucus and Work Session of the Albany Common Council. Ms. Jackson, please call the roll.
Adams. Anani. Ballerin. Clark is out for work purposes. Conti. Farrell. Flynn. Here. Frederick is also out for work purposes. Hoey.
Here.
Johnson.
Present.
Keegan. Kimbrough.
Here.
Love. Here. Robinson. Zamer.
Here.
We have 8 council members present. We're also joined, and 5 absent, We're also joined by Council President Corey Ellis, myself, Shaniqua Jackson, City Clerk, Legislative Aide, Junior Policy Analyst Alyssa Kamara, and Deputy Corporation Counsel Brent Williams.
Okay, thank you. So, in the agenda, skipping to approval of minutes from a previous meeting, I'll be offering the February 20th, 2025 meeting minutes. So we got no local laws, no ordinances. On to resolutions introduced. A resolution by Ms. Love to commemorate March of 2025 as Women's History Month. That's 13/31/25. I would imagine we're all going to be co-sponsors on that, so can you take care of that for us? We'll be moving forward with that. And that's it for the agenda. So, but wait, but we are not anticipating, we have planned for Ms. Keegan to as the chair of the Ethics and Workforce Culture Ad Hoc Committee. She's going to do like a 15-minute presentation. Yeah. Okay, so she's on her way. Stuck. She says she's stuck in traffic, so the clock is ticking. Right. So understandable. Yeah. Oh, at the what the hell is it called? All right, so with that, we're done with our agenda. So we're good to go with that. We're just awaiting Miss Keegan. We don't. Yeah, we're just receiving. We're not. There's going to be 3 of us here by the time she gets here.
What'd you say, Jack? Oh, no, that's Jenny.
Yeah, we don't. Thing is, we don't need a quorum for her to run through her report, do we, Mr.?
No, I mean, technically, if you all want to ask questions about the report, then we should have a quorum, but
We just won't ask questions.
just to have the report, just to, be given the report, no, you don't need quorum.
She's on her way. And for the record, we're joined by Council Member Farrell.
So I mean, to get into the intricacies of the open meetings law issue with quorum, any discussion or consideration that may lead to or leads to action by the body is supposed to happen when there's quorum. So, you know, if there would be some legislative action or action by the council that might come out of discussing this report, then we should only do it should only have that discussion if there's quorum. But if there's no legislative action that's likely to come out of it, then you can get away without having quorum. So take that under advisement as you will. Yes, you are. Carry on.
Okay, so sorry, everyone. So we worked pretty diligently, but had a very sort of short timeline for our first report. The committee was established in September of 2024, and we worked throughout the fall to at least start to gather an understanding of what the allegations against being made by our city workforce were. And I have put together this presentation for you, which is very brief and very general. There's a lot more information in the report, but our legislation that created the committee does require that we submit a report in December of each year. So we apologize for being a few months late, but without further ado, I will get right into it. So I just wanted to touch on the opening introduction because we did provide you all with quite a bit of information about how our civil rights process works, in the barriers in place for everyday common individuals being able to enforce those civil rights. While people have access to the Equal Employment Opportunity Center at the federal level, and the New York State Division on Human Rights at the state level, ultimately, they will get a right to sue letter, and they will need to have the means to find an attorney to be able to proceed in court in litigation. So if they have an employer that's unwilling to act on their behalf, that can certainly become a really significant barrier to enforcing the civil rights that are guaranteed to us under state and federal law. We also provided you in this report with a pretty general overview of what is in the blue-collar workers contract with the city. It does provide and outline the standards for progressive discipline and summary discipline. Summary discipline essentially means that once they've reached a certain point, discipline can be imposed without the ability to grieve. And their contract does allow for summary discipline to essentially restart after refraining from conduct for a period of time. The remainder of their contract is really pretty heavily reliant on Article 75 of New York State Civil Service Law, which is an overarching protection for most government workers in New York State. Under Article 75, whether you have union representation or not, you are allowed to have an attorney or some form of representation with you when you're being questioned with regards to matters of discipline. And if you're being terminated from government employment under Article 75, most employees outside of certain appointments are allowed to proceed with litigation under what's called an Article 78 proceeding in New York State. So their contract relies very heavily upon that component of New York State Civil Service Law. We noted in that report that there are certain discriminatory sections within the contract itself, which is something that was created back in the 1980s. One of the glaring things was that parental leave was only guaranteed to pregnant employees under their contract. So no adoptive families, no foster families, and no one who is a non-birthing parent has necessarily access to that parental leave within their contract. It also doesn't really fully address standard work weeks, standard shifts, doesn't really provide for notice with regards to changing employee shifts or work hours, and that seemed to bubble up as a routine source of concern for union members that were coming before the council. While we as a council body don't have the ability to negotiate those things on their behalf, it is something that we would recommend the city consider addressing in any future contract negotiations. To do that, both the union and the city will have to agree to open those clauses, and would have to come to understanding on that language. But it was a little unusual in my review that there weren't these sorts of aspects in the contract, as most shift work requires, most unions who have workers that are doing shift work will require that there is some sort of notice to employees if you're going to move them from working overnights to a day shift or an evening shift, so that they have the ability to reorganize their lives in order to accommodate that shift movement. So we met on September 25th and December 4th. We received public comment during those meetings outlining numerous allegations, which are all summarized in the report that we provided to you. We also, as committee members, received reports privately from members of city staff and members of the public that occurred outside of those meetings. We advocated for and secured $75,000 for the Office of Audit and Control to conduct an audit into the allegations received during this past fiscal year. We put forth a resolution that was passed by the council body to secure documents based upon the allegations set forth during public comment. To date, we're still waiting for the city to complete its redaction process for those documents. So some of them involved personal information that is not necessarily entirely relevant to the work of the body. So, for example, one of the things that we received were concerns about differentiation and treatment with regards to unscheduled absences from work between workers of color and white workers. And we would need to verify whether there are exigent medical circumstances or medical documentation that the union may not be aware of or other union members may not be aware of, but we don't necessarily need to know what the diagnosis of that particular staff member was. So Corp Counsel, Brett, has been very busy going through tons and tons of paperwork. I did receive word from Rob McGee, I want to say last week, that they are ready for us to start to come in to begin that review process. We also worked with administrative services to update and streamline our policies and procedures related to reporting and investigating allegations of harassment and discrimination. One of the initial things that we found was that the city had an what we would commonly refer to as an EEOC handbook, but then they also had their overarching policy and procedure manual and the reporting procedures for folks who were concerned or wanted to make an allegation regarding harassment and discrimination in the workplace were vastly different between the handbook and the policy and procedure manual. One area required that departments forward those allegations to human resources, and one of the entities required that they do their own investigation. So one of the things that we did manage to accomplish, even in just a short period of time, was to have the city actually review those two documents and come up with one comprehensive policy. Our goals for this upcoming year include obtaining and reviewing the requested records to assist in determining the depth and scope of the proposed audit to be conducted, determine the process for which probationary termination, lesser discipline, and discipline that is more serious is determined. Again, this seems to be based upon the reports that we received, decisions that are being made primarily with human resources that are embedded within departments that are not necessarily corresponding back with our administrative services department. And that may be very critical information to have in terms of assisting the city in ensuring that there is a level and fair playing field for everyone. Continue to receive concerns from current and former city employees, work with the chief city auditor to develop a request for proposal for the ethics and workforce culture audit, maintain open communication with city administration to ensure that matters requiring immediate attention are addressed, research best practices for managing allegations of harassment and discrimination and improving workforce culture, and make appropriate recommendations to the administration, and determine the standards for nepotism within the city of Albany and how that may be best addressed through legislation with regards to the city's ethics or internal policy, because that, again, seemed to be yet another area of concern that was brought forth by the city's union, is who has access and who does not have access or relationships within those departments. And based upon all of that, I think there are several potential avenues for the scope of the RFP. I'm not sure that we will be able to, for what we budgeted, be able to have them look at all of these things. And I think all of our committee members welcome your feedback on the direction for this based upon what you read in this report. But that would include a review of overtime records with corroborating documentation such as vehicle logs and GPS data to ascertain if there's evidence to support the allegations regarding the trade of quote-unquote no-show overtime for quote-unquote bottle service, meaning the trade of drugs, alcohol, and sexual services financed through the city's payroll, which was one of the most common allegations that the committee received. A review of promotions to determine if employees are receiving promotional advancement that they are not qualified for when there are qualifying candidates who are denied such promotions. I would say that that was probably the second most common theme that we heard in all of the testimony that we received. A review of discipline to determine if the contract is applied consistently and fairly across the workforce. And then I think the other piece that we heard a lot was the differential treatment and/or quote-unquote shop talk to address how employees experience the work environment. And the one thing I included in this report that I think is important for the body to understand is that, again, going back to Article 75 of Civil Service Law, if we were to do an RFP, the timeline at which we're asking people to go back from is probably going to be critical, because under Article 75, you can't go on a fishing expedition. I can't go back to 2019 and say that this person did this bad thing 6 years ago. You have 18 months to issue charges. And that is, you know, that is certainly something that we need to consider, and we need to ensure that the folks that are approaching us are also aware of in terms of what can actually be done in response if we do find evidence. However, that timeline may not apply to certain types of criminal activity. So, for example, if in fact there is evidence to support that people are receiving no-show overtime, you know, it's a felony count for every time they clock in and don't work. There are also significant violations for public officers law involved in that scheme, should it come to be that there's evidence to support that. That would sort of change the game, so to speak, if there were any kind of criminal charges levied against departmental staff in relation to the allegations that we received. And I didn't necessarily want to take a lot of your time tonight, so if you folks have questions or if you want to have a discussion about what's contained in the report,
Questions? Mr. Conti?
Can you speak into your microphone, sorry, so because we're recording? Thank you.
Okay, so I'm going back to the slide on the ASME contract, and the last bullet regarding where you make recommendations that the city and union consider addressing these issues, which meaning the ones in the aforementioned, the prior bullet. So the question really is, to what extent do we know, if any, that either party has brought up any of those issues in prior negotiations?
We don't know. I don't believe that the union has necessarily looked at their contract from the same lens that our committee looked at the contract, right? Because our role and our goal was really to broadly look at, are people experiencing harassment and discrimination in the workplace? And there were certainly some things that stood out to us as, you know, being structurally inept, even in how the contract was structured. We can only make that recommendation because under, you know, collective bargaining standards, we cannot direct
Yes,
council
correct.
or the blue collar workers union to agree to crack open that clause. I would hope that they would be willing to consider having a discussion and coming to a broader agreement. The question becomes, you know, because that parental leave guarantee, I think, is like 6 months, and no one else in the city has access to that length of leave. Is the city going to come back and say, we'll fix the language, but we're taking away the 6 months, and therefore no one wants to actually negotiate to address that. The other piece is, you know, it does not have to necessarily be specifically hashed out in the contract exactly what that shift work and or work hours, but typically it's relegated to notice. And typically what I've seen in other labor management contracts is that there's at least a deferral to the labor management process for further negotiation. So you could have the blue collar workers union have multiple different memorandums of understanding for folks who are doing different types of work for DGS, for folks who are doing different types of work for the water department, so on and so forth, based upon the needs of each of those departments. And it's not necessarily entirely based upon what the union wants. It also has to meet the needs of providing services to our residents.
Right.
But in general, it was very glaring to me, because what we were hearing from folks is that shift assignments were being used punitively. You know, so folks would make complaints, and all of a sudden they'd get pulled from an overnight shift to an evening shift, and then all of a sudden, because they didn't have childcare, they can't come to work, and now they're facing termination for time and attendance issues that didn't exist prior to that. And I think with some more structural changes to the union contract that ensures in a situation like that, they have to give you a certain amount of notice before they can do that, or it has to be done via seniority or reverse seniority order. Those types of things may go away, because now you're talking about a potential grievance issue or a potential perb charge for changing the conditions of work without negotiation. I don't know if that makes sense to everyone, but
So issues regarding shift work are probably not universal in every contract that we have,
no.
but I'm looking at issues like the parental leave issue that you highlight, which I assume is a universal issue across all contracts, and I'm wondering if all contracts that we have, collective bargaining contracts, treat that issue in the same way as it does in the AFSCME contract.
I haven't looked and started digging at a lot of the other union contracts. I know our sick leave clauses for the fire department and the police department are vastly different.
Right.
And I think that is certainly a worthwhile task if we can get all of the up-to-date bargaining agreements on the floor for us to review them.
And I'm wondering how, in terms of exempt employees, in terms of our own personnel policies, how that's treated.
If you look at the employee handbook, it defers back to FMLA. So I think even our quote-unquote non-pregnant folks would still be entitled to FMLA, but the FMLA leave that they'd be entitled to is half the leave that is guaranteed to pregnant employees.
Okay. Thank you.
Mr. Robinson?
Thanks so much, and I want to thank you, Megan, and the committee for all your hard work and effort going into this. And I know it was a short period of time, but I want to thank you for your thoroughness in this report, and also with answering the questions. I just have one question about how many employees were interviewed or came forward?
I'd have to go back to the report, because pretty much everyone that we spoke to their testimony is summarized in the report. So I think we've received roughly around 20-ish employees. And in addition to that, I had about 5 or 6 people that contacted me privately that did not want their information made public. Those allegations are woven into that report, but their identities were kept confidential for the most part.
And were there a mix of current employees and former employees in that process?
Yes. So there were certainly people that were currently working for the city, both in the water department and in the Department of General Services predominantly, although we did have some folks who expressed concerns about the Department of Recreation. And we also, both publicly and privately, had former employees contact us with regards to, and in some cases, those former employees were not people who were terminated by the city. They were people who voluntarily left the city and were providing corroborating information saying, you know, I watched footage of the meeting, you know, I received, you know, we had one former supervisor who called to say that they received a promotion that they were not qualified for, and who provided corroborating information regarding the bottle service and a lot more detailed information about how overtime was being used to essentially pay for people's drug, alcohol, and prostitution habits.
Okay, thank you.
Go ahead, Mr. Johnson.
Thank you. One of the things that I was looking for in there is about the point that jumped out at me is people going in the meeting without their union being present. And I thought that that was bothersome. You know, they have people signing, like, if you get in trouble again, you lose your job, letters that the union can't support you if they're not there. So that was troublesome. And just, you know, being from Albany, the person whose time got switched, you know, I happened to work at the school that their kids went to. I watched this young lady change schools so that, you know, she can, around her job. And just, like, I think that issue, like what the councilman was bringing up, it really doesn't stick out until somebody starts using it as ammunition to get rid of you. And so I thought that it was courageous of her to come in and talk about that. And just being a councilman and working for the school district, it gave me privy to information. And so I just was curious about the union piece, and I just remember how strongly the union representative from Rochester spoke about the culture of DGS and from the union's perspective. And I just think that it's an opportunity and it's a space to address some things that seem to be happening all the time, and especially at a time when all we hear from departments is that we're down. And when you have supervisors that are leaving of free will at a time where, you know, people are trying to hold on to their jobs, it just says that something is definitely wrong. And you could just only imagine the calls that I received when they heard about the meetings. There's a lot of people that wanted to say something, but were scared because of the retaliation that happened even to the people that came and spoke. You know, when they went back to work, it wasn't a comfortable atmosphere from them as reported. So I'm hoping that, you know, justice is done for people that were put in difficult situations. And this, you know, we could have got overflowed with people coming in here, and not just from the two departments that we were having discussion, I think what you're going to find out is people are waiting to see what happens here if they want to come through and say, talk about their experiences. Because, one of the gentlemen, spoke about Parks and Rec. And again, I was working in Parks and Rec when a lot of that stuff was going on. I've watched that man work, several different positions. It's another young lady that reached out to me and another person about working in different titles, and only to find out that she wasn't going to get paid. And so I have a sore heart, a sore spot in my heart for stuff like that, because there's a lot of people trying to work their way to the top. They're trying to work their way to opportunities, and it just seems like there's a lot of situations where people are being exploited, under these work opportunities.
So I would say in response to that, if we were to go in the direction of reviewing discipline, I think the concerns that you have over the return to work letters would be part of what that particular part of the RFP would look at. And for folks who were not part of this process, one of the things that is allowable under the AFSCME contract is that if the city is imposing more serious discipline, they can put that person out of work for up to 30 days. So the city and the union essentially have 30 days to play out the disciplinary grievance, and during that time, that person can be taken off payroll. And so for a number, and it is allowable, that's how the contract is structured. Again, I've seen better protections in contracts. For example, the union that I work for, there is if you place somebody on suspension without pay and there's not corresponding criminal charges related to that suspension, they have the right to go through an expedited suspension review. So within 5 days you file, and an arbitrator may return that person back to work. They may still be out of work for a few weeks, but that's a lot different than what our workforce is potentially facing. And you have to remember that our workforce, within AWD and DGS, these are some of our lowest paid workers in the city. And so what oftentimes was coming up in those meetings was that people were facing a potential 30-day suspension without pay. They couldn't afford it. And the city was offering them a settlement to come back to work that basically said if they did whatever behavior they were accused of, and this is before they've had their due process completely played out, before the city's proven its charges, the city accused them of engaging in that behavior again, over the course of 12 months or 18 months, they would be terminated. And then there's no way getting out of that. And that was often done without the union. What I will say is that the way the blue-collar worker union is structured, they rely very heavily on local leadership to do representation. And so that's not to say that their union staffer isn't directly involved in the disciplinary grievance process. But one of the, I think, problem areas is that they're not guaranteed to actually have professional staff present with them when making those decisions. And again, some contracts will, require representation with a big R as opposed to a little r, so that professional staff are there to advise and ensure people understand what they're doing and what they're signing on to. Any other questions, concerns, suggestions, feedback?
I just got one more question. So the RFP process, so we're looking to, after we finish looking over the requested documentation to define the scope, what's the timeline?
I mean, I ideally would like to see that RFP, I mean, because we allocated the funds for fiscal year 2025. So if we don't have those funds allocated and a contract signed by the end of the year, we would essentially have to negotiate for that 75,000 to be put in the budget for 2026. And it would, and that 75,000 that we secured would essentially, if it wasn't spent down somewhere else, would go into the general fund. So ideally, those funds would be allocated before the end of this fiscal year. We don't have enough information to really do an RFP, because an RFP is typically pretty detailed. And if we don't know exactly what we want them to look at, which is why we kind of want to go through documents first, so that we have a better grasp on the scope of the work that we want them to do. And then, you know, those funds are allocated to the Department of Audit and Control, so there's going to have to be some negotiation between the auditor's office and the council on that RFP. But we're, you know, essentially doing a mini audit before doing a big audit, if that makes any sense.
Anything further? Okay, all right. Thank you.
Thank you.
Motion to adjourn? Kelly, motion to adjourn? No, I can't make, I'm not making the motion.